while the Deputy President was hospitalized, and rejecting a reasonable request for adjournment amounted to a gross violation of natural justice. Council emphasized that fairness was the unassailable foundation of any removal process. In support, they cited Gachagua versus Speaker of the National Assembly and 3 others, High Court decision, where the High Court reaffirmed that the right to a fair hearing as non-derogable and that any violation renders the process null and void. Council concluded by submitting that the Constitution does not permit Parliament to sacrifice legality at the altar of expediency, and urged this court to reaffirm constitutional supremacy and protect the sovereignty of the people of Kenya. The petitioners prayed for declarations and that the impeachment process violated Article 10, 118, 145, and 150. A declaration that Standing Order 64-2 is unconstitutional, a declaration that the Senate unlawfully bypassed the special committee, and orders quashing the impeachment resolution. We'll now proceed to the 9th petitioner's case. Sheria Mtaani na Shedrack Wamboi, a public benefit organization, filed the petition dated 18th of October 2024, together with a supporting affidavit sworn by Dorcas Watching His, an advocate of the High Court of Kenya, and a director thereof. The petitioner stated that it is established to assist members of the public in assessing justice, protecting constitutional rights, and promoting the rule of law, constitutionalism, accountability, and good governance. The petition challenged the constitutional and the legal validity of the impeachment proceedings, leading to the removal of His Excellency Gachagua from office as Deputy President, and further questioned the legality of the intended nomination and approval of His Excellency Kindiki as his replacement. It contended that the Senate proceedings conducted on the 17th of October 2024 violated His Excellency Gachagua's constitutional rights under Article 25C, 47, 50, and 45, sub-Article 5 of the Constitution. That the Senate unreasonably declined to adjourn the impeachment proceedings despite being informed that His Excellency Gachagua had fallen ill and had been admitted at Karen Hospital, thereby denying him an opportunity to personally defend himself against the impeachment charges. It was further alleged that the Senate acted in breach of the constitutional requirements of fair hearing, procedural fairness, and natural justice by proceeding with the impeachment in the absence of His Excellency Gachagua, while allowing the proceedings to continue on the basis of strict constitutional timelines. It asserted that although the Constitution contemplated an expeditious impeachment process, the constitutional timelines could not override His Excellency Gachagua's non-derogable right to a fair hearing and adequate opportunity to defend himself. Sheria Mtaani na Shedrack Wamboi further complained that the proceedings before Senate were rushed, insensitive, and conducted in a manner that prioritized speed over substantive justice and constitutional safeguards. Additionally, the 9th petitioner challenged the legality of the subsequent process initiated by His Excellency the President to nominate His Excellency Kindiki as Deputy President under Article 149 of the Constitution. It was contended that the nomination violated Articles 82, 88, and 137 of the Constitution because IIBC was allegedly not properly constituted and therefore incapable of lawful verifying the constitutional qualifications of any nominee to the office of the Deputy President. Sheria Mtaani na Shedrack Wamboi also argued that His Excellency Kindiki's nomination contravened Article 137 of the Constitution on the basis that he remained a serving Cabinet Secretary for Interior and National Administration at the time of his nomination. For these reasons, the organization sought the following prayers. A declaration be and is hereby issued that the rights and fundamental freedoms of the interested party herein to which his rights and fundamental violated by the third respondent on the 17th of October 2024 for declining to grant him an adjournment on the Senate sitting deliberating on his removal from office by way of impeachment. B, a declaration does hereby issue that the decision by the third respondent to have the interested party removed from office by way of impeachment, to the extent that it was done in gross violation of Articles 25, C, 50, 27, 47, and 145.5 of the Constitution, was unconstitutional to the extent of its unconstitutionality, and null and void ab initio. C, a declaration that any subsequent replacement of the interested party, if at all, to the office of the Deputy President of the Republic of Kenya was unconstitutional and therefore null and void ab initio. D, a judicial review order of certiorari does hereby issue to bring to its court, to this court, the decision of the third respondent as communicated via Gazette notice dated 17th of October 2024, communicating the removal from office of the Deputy President from the office by way of impeachment. E, a judicial review order of certiorari does hereby issue to bring to this court the decision of the President of the Republic of Kenya nominating His Excellency Kithure, His Excellency Kindiki as Deputy President of the Republic of Kenya for the purpose of quashing and the said appointment, and that the said appointment failed the qualification for the Deputy President as provided for under Article 137(2) B and 3 of the Constitution. F, alternatively, this court be pleased to make a declaration that the appointment of the Deputy President by the President to fill in the vacancy arising from the removal of the interested party from office pursuant to Article 149 of the Constitution must be read together with Article 82 and 88 of the Constitution to give the IEBC its constitutional mandate to approve the name of the nominee as proposed under Article 149 of the Constitution. G, a declaration be made that the approval of Professor Kithure Kindiki or any other person as Deputy President of the Republic of Kenya is subject to Article 82 and 88 and 137 of the Constitution. Costs of the petition be provided, interest on one above at court rates till payment in full, and this court be pleased to make any further and other relief as it may deem fit in the circumstances. In respect to Moi, the ninth respondent identified three principal issues for court's determination. A, whether the nomination of a Deputy President can be legally finalized or approved in the absence of a fully constituted commissioners of the IEBC under Articles 82 and 88 of the Constitution. B, whether the Senate's refusal to grant His Excellency Gachagua an adjournment due to documented illness during the impeachment proceedings constituted a breach of the rights to a fair hearing and natural justice under Articles 25C, 47 and 50 of the Constitution. And C, whether the nomination of Honorable Kindiki while serving as a cabinet secretary is constitutionally infirm for violating eligibility criteria under Article 148 as read with Article 137. A learned counsel submitted that His Excellency Gachagua fell suddenly ill on the afternoon of the 17th of October 2024 when he was scheduled to defend himself before the Senate, and that the Senate rushed the proceedings and unnecessarily and unreasonably declined to adjourn to allow him to recuperate. That the Senate proceeded with ex parte proceedings leading to his removal from office in his absence, which violated Articles 25C, 51, 47, and 145.5. The organization relied on the Supreme Court decision in Kidero and 4 others versus Waititu and 4 others, reported in 2014, which affirmed that fair hearing incorporates the audi alteram partem principle, and also referred to the Court of Appeal in Judicial Service Commission versus Mutava and another, reported in 2015, KLR, which held that rules of natural justice apply to all bodies exercising judicial, quasi-judicial, or administrative duties. It submitted that Senate has no prescribed time limitation for completing impeachment proceedings, and the rushing was unjustified. It was the organization's submissions that Article 148(1) requires that a person nominated as Deputy President must satisfy the requirements of Article 137 137 and 137 1B, or 137, and that Article 137 1B provides that a person is not eligible for nomination as president and by extension deputy president if they hold any other state office, and that Article 260 defines state officer to include a cabinet secretary. It submitted that at the time of his nomination and parliamentary approval on 18th of October 2024, and therefore he did not satisfy the constitutional eligibility criteria, rendering his nomination null and void ab initio. It was the organization's further submission that at the material time in October 2024, the IEBC was not fully constituted and it lacked the requisite number of commissioners as the previous commissioners had resigned or retired. Articles 82 and 88 establishes a constitutional architecture requiring a lawful and fully constituted IEBC to oversee electoral and nomination processes, and that the Supreme Court in IEBC versus AG advisory opinion number 4 of 2024, reported in 2025, held that a clear distinction must be drawn between administrative continuity by the Secretariat and the exercise of constitutional authority vested in the Commission as a collegial entity. It submitted that the exercise of constitutional functions reserved for the Commission under Article 88, Subarticle 4, cannot be lawfully discharged in the absence of a properly constituted commission with the requisite quorum. It was further submitted that in the absence of commissioners, IEBC was constitutionally incapable from undertaking its mandated electoral processes, and that the approval of a deputy president nominee, the second highest constitutional office, is no less a substantive constitutional responsibility than delimitation of boundaries, and the same principle applies with equal force. The organization urged this court to apply Article 10 on the national values and principle of governance that brings all state organs, Article 20, Subarticle 3B in the Dubia Pro Libertate doctrine, that where in doubt, the court ought to adopt the interpretation that most favors enforcement of a right or freedom enunciated in Jacqueline Okuta and another versus AG, High Court reported in 2017, and that it further submitted that the unconstitutional exercise of a legislative mandate cannot be shielded from judicial scrutiny, as was held in Commission for Implementation of Constitution versus National Assembly of Kenya and two others, 2013, KLR reported. In the end, the petitioner prayed that the petition be accordingly allowed. I now proceed to the 10th to 41st petitioner's case. That's yours. That's yours. Proceed.
Let me take the 10th to 41st petitioner's case. The 10th to 41st petitioners are a group of Kenyan citizens and one registered association, primarily from Central Kenya region. They filed the petition dated the 17th of October 2024. That was amended on the 18th of June 2025 and re-amended on the 16th of December 2025. They challenged the constitutional validity of the impeachment process and subsequent removal of H.E. Gachagua as Deputy President of Kenya, stating that the National Assembly and the Senate failed to comply with Article 152 of the Constitution, which requires them to modify the presidential impeachment procedure under Articles 144 and 145 for the Deputy President. They said that instead they apply the same rules under Standing Orders 64 and 65 for the National Assembly and Standing Orders 78 and 79 for the Senate without necessary modifications, ignoring that the Deputy President does not have the same powers, prestige, or legal immunities as the President. The petitioners aver that this failure rendered the entire impeachment process invalid, null and void ab initio, and violated the right to a fair hearing under Articles 25, 27, and 50. It was their further position that the impeachment was not a genuine parliamentary process, but was engineered, sponsored, and bulldozed by political and financial inducements to capture Parliament, turning it into a tool to remove the DP and settle political scores, thereby subverting the sovereign will of the people who elected the Deputy President in the August 2022 general election. They asserted that the President and the Deputy President were elected on a joint ticket and that the impeachment violated the rights of the petitioners and other voters from the Central Kenya region who voted for that joint mandate. The petitioners also highlighted and incorporated arguments from Nairobi High Court Constitutional Petition 356 of 2024. In that matter, it was alleged that both H.E. President Ruto and H.E. Gachagua had violated their oaths of office and the Constitution through various actions. Specifically, it was claimed that the President accepted foreign gifts valued at approximately Kenya shillings 240 million in the form of paid-for jet hire and fuel costs for a state visit to the United States, thereby exceeding the legal threshold permitted for such gifts. It was further alleged that the President entered into a secretive treaty with the United States to designate Kenya as a non-NATO ally without tabling the agreement before the National Assembly and Senate as required by constitutional oversight. Additional claims included intimidation and threats directed at members of parliament to bypass oversight, as well as inducement of political defections to artificially control the majority party coalition. The petitioners accused the President of using state violence to criminalize and suppress the Gen Z, otherwise read the Generation X good governance protests, as well as the July 2023 protests against oppressive taxation and the high cost of living, and that he distributed state appointments along acute ethnic lines. Additionally, H.E. Gachagua was faulted for publicly dividing Kenyan citizens into shareholders and non-shareholders in quotes, based on political alignments, whereas H.E. President Ruto is accused of spending hundreds of millions of public funds to conduct avoidable by-elections caused by appointing sitting MPs and senators to the cabinet. The petitioners further argued that the Kenya Kwanza Coalition Agreement binds H.E. President Ruto to nominate a replacement deputy president from the Gikuyu, Embu, or Meru communities, which is the same region as the impeached deputy president. They sought a declaration that the president's power to nominate a new deputy president was subject to certification by the IEBC, that the nominee meets qualifications under Articles 99 and 137, stating that the 14-day and 60-day timelines in Article 149 were meant to ensure public participation across all 90 constituencies. Consequently, the petitioners asked the court to declare the nomination and approval of H.E. Kindiki as the new deputy president as unlawful, null, and void. The petitioners thus sought the following reliefs from this court. 1, a declaration be issued to declare that the first petitioner was impeached by the National Assembly and removed by the Senate under a procedure that violated Articles 27, 50, and 150. Declare that the first and second respondents have violated the rights of the petitioners and other voters and residents of Central Kenya region by failing to govern together in accordance with their joint mandate secured during the presidential election held on the 9th of August 2022. 3, a declaration be issued to declare that the first petitioner was impeached by the Parliament under the respective standing orders of the National Assembly and the Senate, that offends Article 150, Sub-Article 2 of the Constitution. 4, a declaration be issued to declare that the impeachment of the first petitioner was null and void ab initio on account of the violation of Articles 25, 27, and 50 of the Constitution, read together with Articles 144, 145, and 150 of the Constitution. 5, a declaration be issued to declare that the second and third to 14th respondents have conspired and schemed to remove the second respondent from office through impeachment in violation of Articles 1, 27, and 38 of the Constitution. 6, a declaration be issued to declare that the second respondent violated Articles 110, 118 and 150 of the Constitution in passing a resolution on 8 October 2024 to remove the second respondent from office. 7, an order of certiorari be issued to quash the resolution of the second respondent passed on 8 October 2024 to approve the motion of impeachment of the first petitioner tabled on 1 October 2024 by the 9th respondent. 8, a declaration be issued to declare that the 6th respondent's power under Article 149 of the Constitution to nominate a person to occupy the office of the Deputy President is subject to certification by the Independent Electoral and Boundaries Commission under Articles 99 and 137 of the Constitution. 9, a declaration be issued to declare that the 14 days period prescribed under Article 149 for the President to nominate a person to occupy the office of Deputy President is to ensure compliance with Articles 10, 38, 99, and 137 of the Constitution. 10, a declaration be issued to declare that the 60 days period prescribed under Article 149(1) of the Constitution for the National Assembly to vote on the President's nomination to fill the vacancy in the office of the Deputy President is to ensure compliance with the requirement of public participation in all the 290 constituencies in accordance with Article 1, 10, 27, 38, 118, and 136 of the Constitution. 11, that by dint of Articles 1, 10, 27, and 38 of the Constitution, the first respondent is bound by the Kenya Kwanza Coalition Agreement dated the 5th of April 2022 to nominate a qualified person from either of the Gikuyu, Embu, and Meru communities to fill the vacancy in the office of the Deputy President occasioned by the impeachment of the second respondent. 12. A declaration be issued to declare that the 6th respondent's nomination and of approval, therefore, by the National Assembly of H.E. Honorable Kithure Kindiki, the second interested party herein, as Deputy President is unlawful, null and void ab initio. 13, the Honorable Court be pleased to issue an order of certiorari to quash the nomination by the National Assembly of Honorable Kithure Kindiki as a Deputy President via Gazette notice published in a special issue of the Kenya Gazette dated 18th October 2024. And 14, a declaration be issued to declare that by dint of Articles 1, 10, 27, 38, 91, and 132 of the Constitution, the citizens of Kenya from the Gikuyu, Embu, and Meru communities have a right secured by the results of the presidential election held on 9th August 2022 to have one of them to occupy the office of the Deputy President during the tenure of the first respondent as the President of Kenya. 15, a declaration be issued to declare that Standing Orders number 64 and 65 of the National Assembly Standing Orders violates Article 152 of the Constitution. 16, an order of certiorari be issued to quash Standing Orders 64 and 65 of the National Assembly Standing Orders to the extent that they apply to the Deputy President. 17, a declaration be issued to declare the standing orders number 78 and 79 of the Senate adopted on the 16th of June 2024 violates Article 152 of the Constitution. 18, an order of certiorari be issued to quash standing orders number 78 and 79 of the Senate as adopted on 16th. 19, an order of mandamus be issued to compel the National Assembly and the Senate, that is the second and fourth respondents herein, to promulgate a procedure for removal of the Deputy President by impeachment envisaged by Article 152 of the Constitution. 20, that a declaration be issued to declare that the first petitioner was impeached through a procedure that amounted to political persecution and vendetta prescribed by Articles 1, 3, 38, and 50 of the Constitution. 21, that a declaration be issued to declare that the sixth respondent engineered, sponsored, and bulldozed the impeachment of the first petitioners in a manner that amounts to abuse of power in violation of Articles 1, 3, 38, 50, and 131(2) of the Constitution. 22, cost of the petition be borne by the first and fifth respondents. The 10th and 41st petitioners' submissions. In these submissions, the petitioners reiterated that the impeachment proceedings did not stem from legitimate constitutional violations. Instead, they arose directly from a severe political fallout and a politics of betrayal, in quotes, between H.E. President Ruto and H.E. Gachagua. They submitted that the impeachment motion was originally assigned to Sirisia MP, Honorable John Waluke, but however, due to his tainted image from a high-profile corruption case, Honorable Mutuse was brought in as a substitute mover to table the motion on the 1st of October 2024. The petitioners listed the following issues for the court's determination. A, whether the impeachment of H.E. Gachagua was a political witch hunt or a genuine procedure. B, whether H.E. Gachagua was impeached by the National Assembly and the Senate under a procedure that violated Articles 27, 50, and 152 of the Constitution. C, whether H.E. Gachagua was lawfully found guilty of Ground 1 of the Articles of Impeachment. D, whether the standing orders number 64 and 65 of the National Assembly and standing orders number 78 and 79 of the Senate, under which H.E. Gachagua was impeached, violate Article 152 of the Constitution. E, whether the Senate's failure to establish a special committee under Article 145(6) of the Constitution. Issue F, whether H.E. Gachagua was subjected to a lawful and fair trial by the Senate. G, whether the first to 11th respondents conspired or schemed to remove H.E. Gachagua from office in violation of Articles 1, Article 27, and 38 of the Constitution. On the weaponization of impeachment for political settlements, the petitioners maintained that the impeachment was completely manufactured by a political fallout rather than the genuine existence of any lawful grounds under Article 151(b) of the Constitution. That it was fundamentally unconstitutional for the executive and parliament to use the sacred device of impeachment as an administrative tool to resolve purely political disputes and vendetta. They submitted that the impeachment proceedings inside both the National Assembly and the Senate were weaponized and conducted in absolute violation of substantive and procedural provisions guaranteed under the Constitution, as well as the standing orders of both chambers. They specifically maintained that the current rules governing the process, that is, Standing Orders 64 and 65 of the National Assembly and Standing Orders 78 and 79 of the Senate, violate Article 150 sub-Article 2 of the Constitution and must be quashed. The petitioners equally submitted that HE President Ruto's power to nominate a replacement under Article 149 was strictly subject to certification by IEBC under Articles 99 and 137, and because the 14-day and 16-day constitutional windows under Article 149 are designed to guarantee rigorous public participation across all 290 constituencies, the rushed nomination and approval of H.E. Kindiki was unlawful. It was null and void ab initio. That rushing this process directly violated the political rights of the petitioners under Article 38. A fortiori, the petitioners argued that this court has an obligation to step in and quash the impeachment to halt an ongoing executive scheme to re-establish an imperial presidency in Kenya, and they warned that Parliament has become subservient and sycophantic to the executive, acting like the single-party rubber stamp parliaments of the late 1980s, which present an existential threat, to Kenya's constitutional democracy. They restated the prayers that sought to declare the impeachment null, void, and an act of political persecution that violated Articles 25, 27, 50, and 150 of the Constitution, and orders of certiorari quashing the National Assembly's 8th October 2024 resolution approving the impeachment motion, and Gazette Notice 13401, which appointed H.E. Kindiki as Deputy President. They also sought to quash the National Assembly Standing Orders 64 and 65 and Senate Standing Orders 78 and 79 to the extent that they apply to the removal of a Deputy President and orders to compel both chambers of Parliament to promulgate a legally compliant, constitutionally envisaged procedure for removing a deputy president under Article 150, Sub-Article 2. The petitioners relied on various local authorities, including the Sonko case earlier mentioned, as well as Jirongo versus Soy Developers Limited. They also relied on foreign authorities, including Kriegler versus the Law Society of Alberta, Republic R versus Budry, R versus Campbell, R versus Reagan, all of which citations you will find in the judgment, all from the Supreme Court of Canada. Further reliance was placed on books, articles, speeches, and reports, as well as interview statement by Senator Edwin Sifuna on the Senate floor as per the Hansard of 9th October 2024 and an interview statement by H.E. Gachagua on Inoro TV. In the end, the petitioners prayed that their petition be allowed as prayed. Moving on to the 43rd petitioner's case, Mr. Morara Omoke filed a petition dated 9th October 2024 before the High Court of Kenya at Eldoret, together with a supporting affidavit sworn on the same date in his capacity as a Kenyan citizen and patriot, acting in defense of constitutionalism, the rule of law, and democratic governance. The petition challenged the constitutionality and legality of the impeachment proceedings commenced against H.E. Gachagua by the National Assembly and Senate. He contended that the impeachment process was politically motivated, defective, unconstitutional, and undertaken in violation of the sovereign will of the people expressed during the 2022 general election. His case centered on the alleged violations of Article 1, 10, 38, 47, 48, 50, 73, 75, 94, 118, 145, and 150 of the Constitution, that the impeachment motion tabled by the Honorable Motuse had not been preceded by adequate public participation, and that the MPs who appended their signatures in support of the motion failed to consult their constituents before supporting the impeachment process. He further alleged that the process of collecting signatures in support of the impeachment motion was tainted by bribery, undue influence, intimidation, and forgery of signatures belonging to some MPs. He contended that the subsequent public participation exercise conducted on 4th and 5th October 2024 was merely cosmetic and incapable of constituting meaningful public participation because it was hurried, poorly coordinated, inadequately publicized, and conducted through only one center per county and constituency. He also complained that the public participation forms contained only the allegations against H.E. Gachagua and omitted his responses, thereby condemning him unheard and violating the principles of fairness and natural justice.